$2 million. That's the number nobody wanted prosecutors to find. Not because it was the largest transaction in the Trump organization's history, not because it represented some catastrophic financial crime on its own, but because of what it revealed about who knew what, when they knew it, and why that knowledge is now sitting in the middle of one of the most consequential fraud cases in modern American legal history. And the person whose name is attached to that money isn't Donald Trump. It isn't Don Jr. It isn't Eric. It's Ivanka. The daughter who spent years building a carefully constructed distance from everything her family's business was doing, the one who said she trusted the professionals, the one who claimed she didn't recall the specifics. Because here's the thing about $2 million. It doesn't disappear. It leaves a paper trail. And that paper trail just made Ivanka Trump the most dangerous witness in this entire case. So what exactly was this payment? And why does it matter so much right now? To understand that, you need to go back to how the Trump organization actually worked. Because the picture that prosecutors have been assembling for years is not just about inflated property values. It's about a system, a deliberate, carefully constructed system for managing how money moved inside the organization, how it was described to lenders, and how it was reported to tax authorities. And somewhere inside that system, there is a $2 million consulting fee that was paid to a company connected directly to Ivanka Trump. That fee is now at the center of a question that prosecutors have been trying to answer for years. Did the people at the top of the Trump organization know that the numbers they were presenting to the outside world didn't match the numbers they were using internally? Because if they knew, that's not sloppy accounting, that's fraud. And Ivanka's $2 million is one of the clearest windows prosecutors have into that question. Here's what the documents actually show. When the Trump organization paid Ivanka Trump consulting fees for her work on specific projects, those payments were categorized in a way that prosecutors say served a very specific financial purpose. By routing the money through a separate consulting company connected to Ivanka, the organization was able to deduct those payments as business expenses. That reduced taxable income. That changed the financial picture the organization presented to tax authorities versus the financial picture it presented to the lenders whose money it needed. That gap, that carefully engineered gap between what the organization told the IRS and what it told the banks, is precisely what the New York Attorney General's fraud case is built on. And Ivanka's fee sits right in the middle of it. Not as an accident, not as an oversight. As a transaction that prosecutors say could only have been structured the way it was if people who understood its implications signed off on it. People like Ivanka. Now here's where it gets genuinely complicated. And this is the part that most coverage is getting wrong. The fee itself might be perfectly legal under certain circumstances. Consulting arrangements between corporate executives and the companies they work for exist in a gray area that tax lawyers navigate every day. What makes Ivanka's situation different isn't the payment, it's the context. It's who she was, it's what role she actually played in the organization. It's what that payment was connected to. Because prosecutors aren't just arguing that the fee was structured in a tax-advantageous way. They're arguing that the fee was part of a broader pattern of financial statement manipulation, that the same organization that was inflating property values to get better loan terms was also engineering its internal compensation structure to minimize its tax obligations. And Ivanka's $2 million is the thread that connects both of those stories. Pull it, and you start to see how the whole system worked. So what happened when prosecutors pulled that thread in the courtroom? What happened when Ivanka sat down in that witness chair and they put that document on the screen? The questioning didn't start with the fee. That's not how experienced prosecutors work. They build context first. They establish what you knew. They get you on record about your role, your responsibilities, your level of involvement in the decisions that mattered. And then they show you the document. They walked Ivanka through her years at the Trump organization methodically, her title, her responsibilities, the deals she worked on, the communications she sent, the meetings she attended. Slowly and deliberately, they were building a portrait of someone who was not a peripheral figure, not a celebrity face at ribbon cuttings, but a substantive senior executive who was in the room when things were decided and whose name appears throughout the financial record of the organization's most significant transactions. And then they showed her the consulting fee structure. And then they showed her the documents that described how that fee was categorized. And then they showed her the communications from that period that showed who in the organization was aware of that categorization. And here's the moment that nobody who was in that room will forget. Because when prosecutors asked Ivanka directly about her understanding of how those consulting fees were structured and why they were structured that way, the answer she gave was the kind of answer that tells you everything about what was at stake. She didn't deny the fee existed. She couldn't. It's in the financial records. She didn't deny receiving the money. That would have been perjury. What she said was that the structure of those arrangements was handled by financial and legal advisors, and that she trusted those professionals to ensure everything was done properly. Think about what that answer actually means. It means she is drawing a line between herself and the decision to structure the payment the way it was structured. She is saying she benefited from the arrangement without designing it. She is positioning herself as someone who received $2 million through a structure that other people built, without necessarily understanding or approving the specific tax and financial implications of that structure. That answer is either a completely legitimate defense or it's the most sophisticated piece of deflection you'll see in a courtroom. And the entire weight of the legal case hangs on which of those two things it is. Here's why prosecutors didn't accept that answer as the end of the story. Because they had something Ivanka's legal team didn't expect them to have in quite the form they had it. They had emails, not general communications about the consulting arrangement. Specific emails from the period when those fees were being structured that showed discussions about the financial implications of how the payments were categorized. Communications that placed Ivanka in proximity to the decision-making about how those transactions would be described. Communications that suggested she was not simply a passive recipient of a payment whose structure she had nothing to do with. When that material went up on the screen, the energy in the courtroom shifted, because this is the difference between testimony about what someone knew and testimony about what someone did. Ivanka had been prepared for the former. The emails complicated the latter. And every attorney in that room understood immediately what that meant for the case. Here's what nobody is explaining clearly enough. When a person is compelled to testify as a witness in a civil fraud case, they don't just answer questions and walk away. They create a record. Every answer they give under oath is now a permanent commitment to a version of events that prosecutors and appellate courts and potentially criminal investigators will be examining for years. When Ivanka said she trusted her financial advisors to handle the consulting fee structure properly, she locked in that explanation. She committed to it. She made it the official version of her understanding of those transactions. And that matters enormously because prosecutors now have two things sitting next to each other that they can compare. They have her sworn testimony about what she knew and how she understood those fee arrangements. And they have documents from the period when those arrangements were made that potentially tell a different story. The question that is going to live in this case for a long time is whether those two things can be reconciled or whether they contradict each other. If they contradict each other, the implications go far beyond the civil fraud case. Because here's the part that everyone who is watching this case closely already knows, but nobody wants to say plainly. This isn't just about the civil judgment. The same financial transactions that are at the center of the New York Attorney General's case are also the financial transactions that federal prosecutors have been examining for potential criminal charges. Bank fraud, wire fraud, tax fraud. These are not hypothetical concerns. They are active areas of inquiry. And a $2 million consulting fee that was structured in a way prosecutors characterize as part of a deliberate scheme to misrepresent the organization's financial picture to both lenders and tax authorities is exactly the kind of transaction that sits at the center of those inquiries. Ivanka's testimony about that fee isn't just relevant to the civil case. It's potentially Exhibit 1 in a completely different proceeding that hasn't been filed yet. And she knows that. Every lawyer in that room knows that, which is why every word she said about that $2 million was chosen with extraordinary care. Think about the position this puts her in. She spent years building distance from the Trump organization's legal problems. She left. She moved to Florida. She stopped attending the political events. She stayed off social media about the lawsuits. She made a calculated decision that the best way to protect herself was to stay as far away from her father's legal battles as possible. And then the court issued a subpoena, and all of that distance collapsed in an afternoon because the documents don't care about the distance she tried to create. The emails she sent in 2012 and 2013 don't disappear because she stopped showing up to Trump Organization events in 2021. The $2 million that moved through her consulting company is in the financial records, regardless of where she lives now. The paper trail that connects her to the decisions at the center of this case existed long before any of this became public. And now that paper trail is in a courtroom. And now her explanation for it is on the record. And now everyone who matters in this legal proceeding is going to spend a very long time figuring out whether those two things tell the same story. Here's what you need to understand about how this ends. Because it doesn't end with the civil case. It doesn't end with the appeal. The $2 million isn't just a number in a lawsuit. It's a data point in a much larger inquiry into how the Trump Organization operated across years of financial reporting. Every document that references that fee, every communication that touches on how it was structured and why, is now part of a permanent record that prosecutors in multiple jurisdictions are working with. Ivanka gave careful testimony. She gave prepared testimony. She gave testimony that her legal team spent weeks constructing to protect her from the worst possible outcomes. But here's the thing about careful testimony when the documentary record is already assembled. Prosecutors don't need her to confess. They don't need a dramatic breakdown in the witness chair. They just need her explanation on the record so they can compare it against everything else they have. And that comparison is happening right now. In offices in Manhattan. In offices in Washington, quietly, methodically, with the patience of investigators who have been building this case for years and are in no hurry to stop. The $2 million transfer didn't just make Ivanka a key witness. It made her the thread that connects the financial fraud allegations to the people who benefited from them. And once you're that thread, you don't get to simply walk away. You wait to see what gets pulled, and trust me, something is about to get pulled. The only question is how much unravels when it does. Stay close, because what comes next in this case is going to be bigger than anything that has already happened. And when it lands, you'll want to have seen this first.